Welcome to this year's issues briefing. My name is Jean Roberts, and I am the current president of the League of Women Voters of Wisconsin. For over 100 years, the League has had a history of nonpartisanship, advocating for research-based positions and not endorsing candidates or parties. Our mission is to empower voters and defend democracy. Over the years, the League has been called partisan by each of the parties if one of our positions disagreed with that party. However, never have we faced the accusations as much as currently. As an organization whose mission is to defend democracy, we are obligated to call out egregious violations of our Constitution, regardless of what is said about us. Defending democracy means defending the Constitution and is not partisan, and the League is not partisan. This year, we offer 3 speakers who will talk to us about the roles of the 3 branches of government enumerated in the Constitution and how those roles are being subverted. Our Constitution was based largely on the influence of the Haudenosaunee Confederacy, who significantly influenced the Founding Fathers. Specifically, the Founding Fathers were impressed with representative government, including consensus-based decision-making, a mechanism for checks and balances, and a multi-state structure. In 1988, the U.S. Senate formally acknowledged tribal influence, recognizing the Haudenosaunee system's contribution to the formation of the American Republic and its democratic principles. Although the Founding Fathers were strongly influenced by the Haudenosaunee tribe, they were not influenced enough to consider the tribe's high status of women.
No problem.
And until the Equal Rights Amendment is in the Constitution, women will continue to be considered unequal in the eyes of the U.S. government. We are meeting on the section of Turtle Island, currently referred to as Wisconsin, the traditional homelands of the Menominee and Ho-Chunk nations. Currently, this land is the home of 12 sovereign nations who have continued to thrive in spite of years of maltreatment at the hands of the government. Current abuses include attempts to strip the sovereign status from and suppress the vote of the indigenous nations and peoples. As an organization, the League of Women Voters must work to gain trust and develop allyships with these sovereign nations to assure that their status and their voting rights are upheld. Early in our history, there was a Menominee Tribal League. Together, the Menominee people and other League members worked to oppose the Dawes Act and thus keep tribal lands within the tribe. However, as the years moved forward, League members appeared to listen less to the Menominee women, leading to the end of the local Menominee League. We need to learn from this and remind ourselves that we are better allies when we listen more and talk less. Our speaker for the first night of issues briefing is Lauren Miller Karolounis, who is counsel at the Brennan Center's Democracy Program, where she litigates voting rights, election interference, and constitutional law cases, advises lawmakers and administrators on legislation and policy, and testifies before state legislatures. Prior to joining the Brennan Center, Miller Karolounis was a Public Rights Project Fellow and Special Assistant State's Attorney in the Cook County, Illinois State's Attorney's Office, where she worked in the affirmative action and impact litigation section. Miller Karolounis has commented on voting and other democracy issues for a variety of media outlets, including the Associated Press, NPR, and Rolling Stone. She has a BA with honors and distinction from Stanford University and earned her JD from Yale Law School. She clerked for Judge John R. Blakey of the U.S. District Court for the Northern District of Illinois. Welcome, Ms. Lauren Miller Karolounis.
Wonderful. Thank you so much. And with that, I suppose I will get started unless there are any other logistical notes that need to be made before I begin.
Go right on ahead.
Wonderful. Well, thank you everyone so much for having me. Let me go ahead and share my screen with you so you can see my presentation. We should be good to go. And again, thank you so much for having me and for that kind introduction. So As was kindly mentioned, my name is Lauren Miller Carolunas. I am counsel in the Democracy Program at the Brennan Center for Justice at the NYU School of Law, where, among other things, I work on cases challenging the abuses of executive power that we're seeing these days. And that brings me my goals for this evening's presentation, which is to answer three main questions for you. First, what authority does the president, as the head of the executive branch, have under the Constitution? Second, how has he abused that authority during the first 10 months of his administration? And third, how have efforts to fight those abuses of power fared thus far in the courts? So we'll begin with perhaps what seems like the simplest question, but is one that I think we often forget the most when we're seeing so much in the news and it's so easy to lose track of all that's going on, which is, what can the president actually do under the Constitution and under Article 2 of the Constitution specifically, which spells out the powers given to the president? And perhaps one we all remember, he can sign and veto bills, of course, subject to a 2/3 vote in both the House of Representatives and the Senate. Another thing, and perhaps the most important thing that the president is charged with doing, is faithfully executing the laws that Congress passes. And what might this look like in practice? Well, he can issue executive orders to instruct federal agencies on how to implement existing laws, or he can direct federal agencies to issue regulations or otherwise offer agencies guidance as to how they should implement laws and enforce them consistently. And of course, he can also make recommendations to Congress about new laws that he would like to see passed, suggestions. And we see that every year in the State of the Union, for example, when the president calls upon Congress to pass his agenda. The president can also make treaties subject to Senate approval with foreign nations. And he can serve as the commander-in-chief of the military. And that includes things like directing the movements of military forces and naval forces. He can commit forces to operations, and he can actually determine the measures of defense required for those operations. Something that we've seen a lot of in the news recently, the president can also grant pardons and reprieves for federal crimes. He cannot do so, however, for state crimes. So state crimes cannot be excused through a presidential pardon. And another thing we see very frequently is the president can nominate cabinet members, Supreme Court justices, and other very high-ranking federal officials of his choosing. So that is what the president can do. Perhaps the more relevant question for this evening is what the president cannot do under the other provisions that exist under the Constitution. So simply put, the president can't usurp or override powers given to the American people through the Bill of Rights or to the other branches of government under the Constitution. So, in other words, he cannot, first and foremost, make new laws or override the laws passed by Congress. And Congress holds that exclusive authority under Article 1, the very first article of the Constitution. The president can also not interpret laws. That role is instead held for the judiciary or the courts under Article 3 of our Constitution. Another very important point, the president cannot decide how federal money will be spent, otherwise known as the power of the purse. Now, I flag this as important because the president also has that power we discussed of being the commander-in-chief. And building on the lessons of our British predecessors, the framers really thought about this hard. They thought it was particularly important to separate the power of the sword, commander-in-chief, from the power of the purse, federal funding, to prevent the tyranny that they had experienced under the monarchy or the king. So in other words, they felt really strongly that allowing one person to both fund and deploy the military could lead to the exact same situation that they had just rebelled against. So that is something I want us to remember as we get to efforts to attack federal funding later on. And of course, speaking of commander-in-chief and war powers, only Congress can actually declare war, formally at least. And we actually haven't seen as such since World War II, so quite a long time at this point, but that is a power that is explicitly reserved to Congress. And finally, the president cannot choose those cabinet members, Supreme Court justices, or other high-ranking officials we mentioned without Senate approval. The Senate has to give its advice and consent at the end of the day. So now that we have an understanding of what the president can and cannot do, I find it really helpful to break down how the president has abused this authority by considering how his actions have violated the constitutional checks and balances that exist to protect the other three most important entities in our democratic system. That is the American people, Congress, and the judiciary. And for each of those relationships, I could provide a lot of examples and we'd be here well past 8 p.m., but I will instead provide just a few examples that I think really illustrate how the president has tried to seize powers given to these other branches of government during his first 10 months in office. And we'll start with perhaps the most important relationship of all, that is the relationship between the president and the American people. And perhaps the most jarring and first and most notable example of how the president has tried to take away rights constitutionally guaranteed to the American people has been his efforts to revoke birthright citizenship, which is protected under the 14th Amendment to the Constitution. So first things first, what is birthright citizenship? Section 1 of the 14th Amendment states that all persons born or naturalized in the United States and subject to its laws are citizens of the United States and the state wherein they reside. And after that amendment was passed, the Supreme Court confirmed as much in a very landmark ruling way back in 1898. They said, of course, the children of parents who are not even U.S. citizens, if they hold temporary status or otherwise not documented, are considered, if they are born here or naturalized here, citizens of the United States. But on his first day in office, President Trump issued an executive order that tried to remove this protection or override the Constitution. And specifically, that order would deny citizenship to any baby born in the U.S. to a mother who was present unlawfully or lawfully, but temporarily, and a father who is not a United States citizen or a lawful permanent resident. So in other words, the US-born children of undocumented immigrants or the children of parents residing in the country under a temporary authorization, like a work visa or a student visa, for example, would not be considered US citizens. So practically, these children would still get birth certificates issued by local governments, but that would no longer be considered proof of US citizenship necessarily. So how might this play out in the real world? What that would look like is hundreds of thousands of children born in the United States would be denied citizenship, creating a new subclass of people lacking the full rights and protections long enjoyed by citizens. And some of these children, in a really complicated and problematic way, would be rendered stateless, meaning that they wouldn't be recognized as citizens of any country, or in a worst case scenario, they would be deported to foreign countries where they have never lived or where their welfare would be endangered. And not as important, but also really impactful, this also just would create a lot of administrative problems. Government offices would no longer be able to rely on birth certificates to determine citizenship, leaving them with a whole host of questions on how to implement this. And also, everyone in the United States would be vulnerable to having their citizenship questioned by government officials if a birth certificate was no longer considered proof of citizenship. So how have efforts to challenge this order fared thus far? They certainly have been challenged in court by many, many different groups and people. And as we discussed up top, the president can't interpret the Constitution however he chooses. His only duty is to faithfully execute the law that already exists. So thus far, the order itself has not made its way all the way up to the Supreme Court on the merits or the legal issues that are really at stake here, whether or not this is unconstitutional. Rather, it's still proceeding through the kind of mess and bogged down atmosphere of the lower courts and the intermediary courts. But as it does so, the order has been stayed, or what we call paused rather, in the court system. So it is not currently in effect. And the Supreme Court will actually decide whether to take up the issue at the end of the calendar year, likely setting it up to be decided sometime next year. But it's important to note that, if this even doesn't go into effect, ultimately, at the end of the day, it's had a really chilling effect thus far on the people who might be affected by it. Now, another way that the president has abused his authority by interfering with rights guaranteed to the American people is by violating First Amendment rights, specifically the right of the public and non-government actors to engage in constitutionally protected speech or expression without retaliation from the government. So what are some examples of this? We'll go through, and what has happened when the targets of that retaliation have challenged the government in court. For one notable example is that the administration froze more than $2 billion in already awarded grants to Harvard University after the school declined to change its curriculum to conform to the president's policy preferences. But after Harvard brought a First Amendment challenge to this in court, a judge sided with the university and ordered the funding to be restored, saying it was a blatant First Amendment violation. Similarly, the president tried to limit the Associated Press's access to events after the outlet, you might recall, announced it would not follow his lead in referring to the Gulf of Mexico as the Gulf of America. But a judge appointed to the bench, actually by Trump in his first term, made clear that this was a First Amendment retaliation in violation of the Constitution. And specifically, the judge ruled that if the government opens its doors to some journalists, it can't then shut the doors to other journalists because of their viewpoints. In a series of other cases that were in the news quite a bit, the administration has tried to deport individuals with varying forms of different legal status in the US, student visas, for example, because they've expressed political views that are at odds with the president. And across the board, the administration has lost all of these cases in court at this point, as, again, just blatant examples of prohibited First Amendment retaliation. And you may have also seen in the news as well that in another series of cases, major law firms have challenged executive orders that punish them for employing the president's perceived political enemies or representing clients who have challenged his initiatives in the past. And the judges considering those cases found the orders to be, and I quote, an egregious violation of the First Amendment. So walking through all these examples, I think the takeaway is that while the president has the authority to execute or enforce the laws thus far, and so far the Supreme Court has not had a chance to consider all of these cases, courts have really held that it can't violate those laws. They have held that the president cannot violate the First Amendment by targeting his political enemies. The lower courts considering birthright citizenship cases have found that it's a blatant violation of the 14th Amendment. But again, nevertheless, the chilling effect is really undeniable here. And there becomes a chance that people just speak out less or they start policing their actions when you have these abuses of power where the president is trying to take away rights guaranteed to the public so blatantly, even if ultimately at the end of the day they are unsuccessful. So that is the president and the people. Moving on, we'll get to the checks and balances that I think, or the checks and balances relationship that is, where I think, at least in my opinion, we've seen the highest volume of attempted abuses of power. And that is the president's relationship with Congress. And when I think about Congress, there's a clear reason that the Constitution gives Congress and not the president broad authority to pass laws and spend money and otherwise shape government. And that is because it's the branch most directly accountable to the American people. It's how James Madison said it himself in the Federalist Papers so many years ago. The public directly elects its representatives to legislate in a way that meets their community's specific needs. Those representatives are on the ground in their communities, or they at least should be. And in contrast, as we discussed, the president sitting in the White House, his only duty is to follow and execute the law as Congress enacts it. And while truly so many of the actions we've seen thus far demonstrate the White House's desire to overhaul this arrangement, this has been perhaps the most true at this point with respect to the president refusing to spend federal funds appropriated by Congress. So we'll go through quite a few examples of that because there are just so many, and I think it's so difficult to parse through all of the different ones when we see them in the news. So again, why is this problematic? As we already discussed, the Constitution gives Congress the power of the purse, the authority to decide how much money the federal government spends and for what purposes. And this is interesting in part because some of you may well remember, because it's within many of our lifetimes, this is not the first time a president and Congress have engaged in a battle over funding. It has happened before. So long before Trump, President Nixon said way back in 1973 that he had the unilateral right to block or impound is a word that's used a lot in these conversations, billions of dollars that Congress had appropriated for medical research, higher education, public housing, the environment, many other projects. And Congress pushed back very strongly. In 1974, it enacted a law called the Impoundment Control Act of 1974 to protect its power of the purse. And we now see that law being mentioned in the news quite frequently today. And that law reinforced what its sponsor said the Constitution required, that the president faithfully execute congressional commands, including those concerning spending. And among other things, the law requires presidents to ask Congress for permission before it refuses to spend or impounds funds that Congress has already approved. But these impoundments, even though this has been very settled law for decades, are very much now back in the news. Since returning to office, the president has routinely refused to spend appropriated money without asking for that permission. He has paused and canceled and clawed back funds for things like education and health, foreign aid, and countless other initiatives. So we'll take a look at some of these efforts in more detail to see what these might look like and how they're all related. So the first thing that the president did when coming into office, or one of the first things, was that on January 27th, he enacted a funding freeze. And that was through Office of Management and Budget memorandum that directed federal agencies to temporarily pause nearly all federal financial assistance while the government reviewed whether the funding aligned with the new administration's policy and personal preferences. Now, the pause applied to all forms of grants and loans and insurance not received directly by individuals, amounting to billions of dollars that Congress had already authorized and appropriated for really essential services. So things like education, healthcare, and public safety, things that had considered and said, yes, we need funding for this without question. So federal agencies, which received notice of this pause less than 24 hours before it went into effect, had no choice really but to quickly comply. And within hours, they had initiated freezes that indefinitely suspended all payments on a sweeping range of government programs, and even funding that wasn't supposed to be covered by it fell victim to those freezes because there simply wasn't enough time for the agencies to parse through and figure out what was affected. So state Medicaid payment portals went offline, early education centers couldn't access Head Start funds, and small businesses lost access to really critical grants that they had already been awarded. And now this freeze has been temporarily paused by litigation, but the fact remains that it could be reinstated at any time based on a court order as courts are considering this question, leaving all of these federal funding recipients in a really tough bind of uncertainty of not knowing whether their funding will continue and if they should continue programs and services and if they need to keep staff on or if they should fire them, creating just a huge headache across the entire country with these billions of dollars at stake. Now, in the meantime, separate and apart from the funding freeze, administration officials have also sought to slash federal spending by other means, including by terminating massive amounts of government grants that have already been awarded to, according to congressional appropriation laws. So one notable example that I think is worth spelling out is that the administration has terminated over $2 billion in grants awarded through the NIH, or National Institute of Health, a decision that experts warn will lead to things like fewer breakthroughs for diseases like cancer, a weaker public health response against future infectious disease threats, and also just a continued decline in trust in public health institutions, not to mention just an exodus of qualified healthcare researchers who are no longer able to be funded by American health institutions. So often we see these numbers thrown around in news articles or online, and we think, well, what does that mean? It's important to talk about these harms and what that means for our long-term future when we just terminate these billions of dollars with no ability to get them back anytime soon. So another big example that I like to draw folks' attention to is at the administration's direction, the National Science Foundation has terminated over $1 billion in grants devoted to scientific research and innovation. Again, grants that have already been approved by Congress. And some people think, well, why does the government need to be funding things like science and innovation and research anyway? Private companies can do that. Well, historically, the grants that were terminated were grants that have done things like contribute to major breakthroughs in our country. Things like organ transplants and the science behind it, smartphones, the internet, extreme weather and other hazard warning systems, even American Sign Language was funded by a National Science Foundation grant that contributed to its research. So in other words, those grants are contributing to projects that it's important for the government to fund because while the long-term impact is really large, it requires decades and decades of research. So there's little incentive for private companies to do that work because there's no short-term financial reward. So it's the government that actually steps in and provides the foundation for it. So again, just another impact to think about when we think of how these threats to funding play out in real life. Now, another thing I like to mention, because I think it's in the news a lot, but I don't think a lot of people know what it means, including myself, until it happened this year, is something called a pocket rescission. And it was what occurs when a president asks Congress to rescind or cancel funds very close to the end of the fiscal year, which is September 30th in most years. And the president asked to rescind that funding so close to the deadline of the end of the fiscal year that the funds expire before Congress has a chance to act on the request. So they're never used, even though Congress has appropriated the money. It has long been held since the Nixon administration that these pocket rescissions are not legal. But the president has nevertheless already tested this theory out this year in September, right before the end of the fiscal year. He rescinded almost $5 billion in international assistance funding that Congress had already approved for, among other things, international peacekeeping efforts and United Nations operations. So that is a lot on funding, but now that we've walked through all of these instances of the president trying to seize Congress's power of the purse, the elephant in the room question remains, have these affected local governments and states and nonprofit organizations? So many people have been able to challenge these in courts. And so far as was indicated a little bit, the results have been mixed. In some instances, the lower courts have temporarily paused the different cuts, things like the funding freeze, while the various cases challenging it make their way through federal appellate courts. But still, as we've discussed, the uncertainty has been extraordinarily damaging, as people have no idea whether their funding will be revoked in the future, depending on how the cases play out. And in other instances, the funding has unfortunately been forever lost as the fiscal year ran out on September 30th, meaning that we just won't get those billions of dollars back for critical scientific research. When it comes to the Supreme Court in particular, a lot of these cases are just still percolating through the court system. It hasn't been asked to weigh in directly on these issues, but the administration has been very savvy in building up lots of tiny wins on technical issues before the Supreme Court, with the effect of really narrowing Congress's power and expanding that of the president in the meantime, while the Supreme Court waits to hear these cases on their big merits. And with that in mind, I want to close out our funding section with a note on what this might mean for the end of the government shutdown, which is, I know, what we're all hearing about every day. Because in ending earlier shutdowns, the two parties have historically made a funding deal and enacted legislation to reflect that deal. But now the party out of power, in this case, the Democrats, have no motivation to compromise given the president's refusals to spend money that they allocate in legislation. In other words, if they know the president is going to refuse to spend money that's appropriated in any legislation that they pass, why would they strike a deal? Why would they agree to pass legislation? So in short, that's one of the many reasons why it's going to be very difficult to come to a good faith compromise to end the current stalemate in Congress, because there's really no incentive to negotiate at this point. So we can see this might be a long road ahead for that reason. Now, moving on to another congressional aspect, I want to address a topic that I think gets less coverage in the news than it actually probably should, because it serves as a very large abuse of executive power, and that is the president's attacks on independent federal agencies. So, specifically, one of Congress's most important constitutional powers is the power to create and shape and oversee the many independent federal agencies that exist to serve the public good in our country that Congress has created. These agencies range from the Federal Reserve to the National Labor Relations Board and the Federal Trade Commission, for example, and they make critical, often very, very technical decisions on matters ranging from financial markets to transportation issues and toxic substances, things that require a lot of expertise rather than political know-how. And Congress made them independent agencies for this reason, to ensure that their decisions on such important and complicated matters follow the law, they make good policy sense, and they don't follow the whims of any president's personal policy preferences because they affect Americans' everyday life. And so to safeguard that independence, Congress gave the heads of these agencies fixed terms, and they set specific criteria for when they can be removed early, such as when they engage in malfeasance or really bad behavior, acknowledging that they should only be removed early that is outside of their terms in really rare circumstances, because it's so disruptive to remove such an important official who should be an expert in the middle of their term as they're enacting all of these complicated, really important policies. The president, however, has ignored those protections and removed board members of several independent agencies. So that includes board members of the National Labor Relations Board, the Federal Trade Commission, the Federal Reserve, I think has gotten the most coverage. And he has done so without any reason or process that Congress would recognize as legitimate before their terms have expired. So what we're really seeing the administration saying is the president should be able to unilaterally fire federal agency heads whenever he wants and for whatever reason, at the risk of turning these federal agencies into political machines with the power to upend so many aspects of Americans' day-to-day lives. So several lawsuits have argued that the firings violate the clear language of these protections that Congress set out in legislation, and the Supreme Court is set to weigh in on this issue very soon, possibly by the end of this calendar year. And when it does so, the thing to keep in mind is that the court won't just decide this, what seems like a technical question of whether the president properly removed these agency heads from their office, but also this really profound question of whether the president can override Congress's longstanding laws governing firings and agency heads' terms of office, which, if it does, will have long-term ramifications we'll be dealing with for years to come. And related to this, I want to briefly address something that you may have seen happening, which is very much ongoing: the administration's attempts to shut down altogether or dismantle independent federal agencies. So consider, for example, the Consumer Financial Protection Bureau, which I think is a good example because it's something we all agree is pretty objectively a great nonpartisan agency. The Constitution gives Congress the power to regulate commerce. So in the aftermath of the 2008 financial crisis, Congress used that power to create the CFPB and charge it with supervising and regulating financial institutions all across the country and helping consumers harmed by those institutions. But soon after taking office, the Trump administration set out to quote unquote totally eliminate it based on tweets that they put out. He fired and replaced the director of the agency. The successor who took over as the director quickly proceeded to refuse all future funding for the Bureau. They directed staff not to perform any work tasks whatsoever. They closed the headquarters, canceled $100 million in contracts, and they fired as many employees as they could as quickly as possible. Now, these cases that have tried to challenge these attempts to dismantle federal agencies, and there have been many since, have had a hard time in front of courts, which again haven't actually decided the core issue of whether the administration can shut down entire federal agencies yet. but rather they've had a really hard time addressing a technical threshold question, which is pinpointing when exactly an agency has been shut down or dismantled. Is an agency still an agency, for example, if it only has 50 employees compared to its usual 1,500? When is the point that it no longer exists? So the end result still remains to be seen as the courts try to parse out these really complicated factual questions. But the reality is it could take decades to build back these agencies now that they've lost so much funding, they've lost all of their staff. By the time the court finally considers this question of whether the president has the authority to dismantle them. So in addition to trying to fight these court cases, I think what a lot of folks are thinking about now is how are we going to do the hard work of building them back in the future? Now, last but not least, we'll close out, and I promise we'll end on a more uplifting note. But we will close out by discussing first the president's relationship with the judiciary before we take a look at what's ahead for the country and the courts. And specifically, we'll look at how the administration and government lawyers representing the administration court have abused their power by refusing to follow court orders. That is one of the most important principles in our government separation of power system. So by at least one count, as of a few weeks ago, this might have changed. But according to the Washington Post, the White House has defied 1 out of every 3 judicial rulings that have prohibited the president's actions. And this noncompliance has taken several different forms that we've seen. In some cases, the noncompliance is very blatant and obvious, as it was when the administration unlawfully sent one individual to El Salvador, for example, in an immigration case, despite a court order that said you cannot remove that person to that country. In other cases, the government has failed to comply with court orders requiring it to restore federal funding and programs that have been unlawfully terminated, and instead they've simply continued to withhold that funding or refuse to operate federal programs, even though they've been required to do so by a court. And in some cases, the administration has continued to fire federal employees in the face of orders that have prohibited them from doing so, even though the orders say you very clearly cannot do this. And they have benefited because it is very hard to hire people back once they have already been terminated. They may have retired, they may have chosen other jobs. It's hard to get those people back in offices. Now, the administration has offered varying reasons for why they have refused to comply with some court orders. In several instances, the president himself or other agency officials or administration officials have said these judges are biased against them and their rulings are bogus and they shouldn't have to follow them. In other cases, Department of Justice lawyers representing the president have said that they simply misunderstood the judge's ruling, or that the actions took place due to miscommunications or accidents despite the court order. And in some cases, it's easy to see that's said in bad faith. In others, it seems like perhaps the Department of Justice has lost so many federal employees that maybe they are legitimately confused and understaffed and aren't quite sure what's going on. But the fact remains that in many ways, these refusals are very dangerous. Courts have several ways to enforce compliance, of course. They can do things like hold parties in contempt. They can fine them. They can sanction lawyers and threaten to remove their law licenses. But these actions can often take a lot of time because they are so serious and so significant. And often courts may also be reluctant to come right out and say that the president has defied a court order outright. Because it suggests perhaps that we are in a constitutional crisis or might reach one at some point. And that is an instance where you don't want to cry wolf if it is not 100% true because it is such a serious threat. And we also know that the president's rhetoric about judges being biased against him is also having a very dangerous effect, with judges appointed by both parties taking a really remarkable step that we haven't seen before, which is speaking out to the press and in statements about the threats of harm they've received as a result of their rulings against the administration. The rhetoric of violence is just very, very strong, as we've seen in this country right now. And by constantly criticizing the courts, these judges have faced just an unprecedented level of threats against them. So what does this mean going forward for the courts? It's not all as bleak as it sounds. Typically, when the government litigates in cases before courts, they enjoy something that's called the presumption of regularity. This presumption, because they are such a frequent player before the courts, they are so often there that the courts assume, for the sake of argument, that what they say is true, that the processes they have taken are, as they say they have happened, are accurate, and they don't have to really dig behind it. They just assume that the government has done its due diligence. And something has happened that we've never seen before, which is more and more courts are saying that the government no longer enjoys this presumption. The default is now verify before you trust, and courts are really, really digging into what the government tells them and whether or not that is true. They are also crafting orders that are far, far stricter than they've ever had to be against the government. So nailing down to the tiniest detail in their court orders what the government can and cannot do. So it's much more difficult for the government to wiggle out of it. And we will see eventually these cases starting to reach the Supreme Court, where perhaps the government has not followed a court order. It has not really reached them yet. And it will ultimately be up to them to set the boundaries of when the government has gone too far. And we've seen some indications that this may be a bipartisan, across the aisle, regardless of what president appointed which justice issue, because again, no one likes to see their colleagues threatened in this way due to this rhetoric by the president. So we do have some silver linings there. Now, before we launch to questions, because I want to make sure we have plenty of time to discuss them, I want to make sure we discuss looking ahead, perhaps the less savory things we might have to look forward to, and also the hopeful things that we have to look forward to when it comes to our democracy and abuses of executive power. So first, something that we've mentioned several times already this evening, the Supreme Court, and in particular, I want to discuss something what's called the shadow docket of the Supreme Court. Because at this point, as we've discussed, the Supreme Court hasn't had a chance to weigh in on the core legal issues of what's at stake with the president's abuses of power, since these cases have only reached them at this point on what's known as the emergency or the shadow docket. Now, the shadow docket was previously a rarely used procedure for the court to issue certain emergency decisions. Normally, the court decides cases based on a very thorough briefing and oral arguments that culminate in written decisions that very clearly lay out the court's decision and its reasoning in doing so. And this allows the public to really evaluate the court's justification and imposes discipline on these justices' decision-making process. It makes them accountable for their actions. The shadow docket, in contrast, provides a fast-track process for the court to hear emergency applications. And that typically involves requests that the court temporarily lift or pause lower court orders. Historically, this process was used very, very infrequently and limited to instances where an applicant faced serious, truly irreparable harm. The most common example being a death row inmate facing execution who was trying to get an emergency pause on that order so the court could consider whether or not the execution was valid. Shadow docket cases, for that reason, because the emergencies are considered to be so dire, involve limited briefing, no oral argument that the public can listen to, and rulings with little or no analysis of the court's reasoning. And what we're seeing now is the Supreme Court is now using the shadow docket at an unprecedented rate for lawsuits challenging the Trump administration's most controversial actions in cases that really don't compare to that incredible emergency of a death row inmate facing execution. So in its first 20 weeks, for example, the Trump administration made as many shadow docket applications, 19 in total in those first 20 weeks, that the Biden administration made over 4 years in office. So it's just an incredible frequency that we haven't seen before. And the reality is that the administration has prevailed in the vast majority of these requests for emergency relief in front of the Supreme Court, which allows its policies to move forward after lower courts had found that the administration's actions were likely illegal. And while these decisions aren't actually the final ruling on the merits of the issue, there's still a really significant impact on the people affected while these cases remain pending and this bad behavior is allowed to go into effect while that's the case, which is what, and it's why the lower courts issued their orders in the first place. So among other things that we've talked about this evening, the court's shadow docket rulings have led to the mass firing of civil servants while cases play out, the defunding of scientific research, and another notable example recently is the racial profiling and immigration sweeps that have been allowed to continue with, again, just little to no reasoning from the Supreme Court, sometimes just a paragraph, sometimes even less than a paragraph, before they even hear oral argument and really get to address all sides of this issue. So that's the bad news, but I promised we would end on good news. And the good news is in part one, that the vast majority of the lower courts that have actually had that full briefing and argument on the merits of these questions and had the opportunity to really consider the issues at stake, they have overwhelmingly decided against the administration when it has abused constitutional powers. And while the Supreme Court is still uncertain when it comes to how they will address these cases when they actually reach them on those merits, it's going to be really difficult for the court to wiggle out of some of these clearly unlawful actions when it's forced to actually provide an explanation for its ruling. And we'll close by saying that lest the hope of long-term success in front of the Supreme Court of these other courts not bring you relief right now, I want to end on another hopeful note, part two, which is that our federal constitution, our federal checks and balances are merely the floor of the rights we have as US citizens. And actually the states and the state constitutions are the ceilings. The states have a lot of power to craft their own constitutions, their own Bill of Rights. And they are in fact doing so in response to a lot of these actions that we've seen at the federal government. So one of the most important things we can all do right now is support and lobby our state legislatures and our local governments to advocate for checks and balances that we believe in, to advocate for changes, increased protections in our state constitutions, and of course to go out and vote for these policies when they come up on the ballot, whether that's in elections in your locality, perhaps this year, or of course, we'll all have the opportunity to vote in the midterms next year. So there are still things we can do. There are still things we can change, even in the face of these abuses of executive power. And so with that, I will make sure we leave plenty of time for questions. I'd love to hear your thoughts and feedback and any questions you might have.
Thank you, Lauren. I am sure we have tons of questions. And so I am going to pass it along to Anastasia Saluna, who is going to facilitate our Q&A portion of this session. So Anastasia, I know we've got some in the chat already. And again, you're welcome to put your questions in the chat. You are also welcome to ask your own question by raising your hand.
Thank you so much, Lauren, for that presentation. That's so much good information for everyone. We have a number of questions related to funding and the financial aspects. So let's go ahead and start out with that. One question I saw, is there an estimate for how much money has been spent on lawsuits to challenge the president's actions?
Oh, that's an excellent question. On money on lawsuits spent to challenge the administration's actions. I think that's a number that's hard to quantify for several reasons, part of which is because the people bringing those cases are often state and local governments with their own departments set up to bring these cases. So not necessarily outside funding or anything you can quantify, it's just government offices. And then another large group of people bringing these cases are nonprofit organizations bringing these cases on their own dime with pro bono lawyers, not because they want to, but because they have to save the existential threat of their organization. So in terms of how much money has been spent actually bringing the cases, I think it would be hard to quantify, but perhaps at least for nonprofits, not much, because a lot of these people are doing this for no profit whatsoever.
Thank you very much. Renee, I see your hand is raised. Go ahead.
Yeah, I just want a follow-up question on that. Thank you, Lauren. can we find an estimate of how much of my tax dollars are spent defending these actions? That's, I think it might be more quantifiable.
Yes, that's another excellent question. I would anticipate a lot of taxpayer dollars defending that. That, of course, will require the federal government to release that information. But it's an excellent question that I'm not sure of the answer to off my head of whether the Department of Justice releases data on that front of whether they will tell you how much money they've spent defending actions, but it's something that I think would be worth looking into, and I will certainly look up in my own time, and you are welcome to email me about that as well, because it's a fascinating question that I'd be curious if we could figure out.
Thank you. And then we have some nitty-gritty questions about the withholding of funds that have been approved. One being that if the Office of Management and Budget holds the literal purse strings, doesn't that ultimately mean the president is withholding designated funds? And then weren't the grants awarded through contracts? Can they ignore legal contracts?
So I will take the second part of that question first. So the first part is, weren't those grants awarded through contracts? The answer is yes, they were. Congress sets out the laws as to how the money should be used. And then people apply for the grants through federal agencies. And then essentially a contract is formed in many ways between the individual grant recipient and that agency. And so there are some contract claims there. And what people have now found is that while a lot of the initial cases challenged just a huge termination of billions of dollars in grant money all at once, while those cases are stalled in the courts, people are starting to bring individual cases challenging the termination of their grant money. And those are contract cases. And that is in a court system called the Federal Court of Claims, which handles specific government contract cases. So those cases take quite a bit of time, so we won't know how they play out for a while. But that is a legal strategy that many folks are certainly considering approving for that reason. And you may have to remind me of the first question about OMB and the power of the purse strings. I remember it being a thoughtful one.
Absolutely. The question was, I'm sorry, hold on. Does it mean that the president is withholding designated funds if that office holds the literal purse strings?
Yeah, so the president is withholding federal funds, correct, because Congress spells out how the money should be funded, and OMB distributes that money according to Congress's directives. Now, there are some instances in the law where Congress has said, this money is for X purpose, and you, the executive branch, actually have some discretion in figuring out how to exactly carry that out and disperse it. So the OMB does have some discretion in some instance, but it does not do so across the board. And there is other funding where Congress very clearly says, no, there is no discretion. You have to spend this money in this way. And so when the president terminates or refuses to spend or withholds that money across the board in a sweeping way with no consideration of all of those individual determinations it would have to make if it was actually following the funding laws, that is certainly withholding federal money in violation of power of the purse.
Before we go forward, I would love it if you would maybe stop sharing so we can see you a little bit larger.
Oh, yes, of course. And I think
not
you
to
may...
worry, not to worry. I put your email address in the chat and I'll share it because I know that you have it nice and available for everybody here. We would just love to see you a little bit larger on our screen. So if you don't mind taking a moment to do that, I will drop your email in the chat for everybody.
Of course. And you may actually have to stop me from pausing. It appears to be not cooperating. We'll see. There we go. Thank you so much.
Awesome, thank you. Near the beginning of your presentation, we had a question about the executive branch interpreting law. Doesn't the executive branch interpret laws through its administrative law procedures?
It's an interesting question of whether it interprets laws through independent agents or through administrative law procedures. So I think what the question might be asking is there a way in which the president is allowed to interpret laws if he's directing federal agencies to do something? Because he's presumably telling them to follow the law in a certain way. And so what the president can do is he can say, I think the law means this, and therefore this is how I recommend you carry it out. But of course, whenever an administrative agency actually does implement a law, people can sue to challenge it and say, this isn't correctly implementing the law. You are interpreting the law incorrectly. That happens all the time, and that's normal. And it's a good faith process where sometimes a court will step in and say, you thought the law means this, it actually means this instead. But we've seen in this administration is actually saying, I know the law technically was supposed to mean this. I'm going to reinterpret it in an entirely different way, consistent with my own beliefs. So it's not a nuanced, technical, good faith, different interpretation. It's actually trying to change the meaning of the law itself that we're seeing now through the administrative process. And I hope that answers your question, but if it doesn't, please let me know.
Perfect, thank you. We have a number of questions in the chat as well about the courts and the thing that everybody is hearing more about and sighing greatly about, the shadow docket. Can you comment? I know you covered it a bit. Could you comment a little bit more about the shadow docket enabling the administration's attacks on federal agencies? If the SCOTUS ever does get to the merits stage and decides against the administration, how will these decisions be effectively enforced, especially given the timeline for that? And then as a little addendum to that question, is there anywhere we can see the shadow docket approvals all in one place?
This is interesting. Well, the last part of your question I will start with first, and that is because we at the Brennan Center have recently created a shadow docket tracker. So let me pull that up for you. And I will put it in the chat right now. So you can see everything in one place and keep track of it. But I think you're raising all of the right questions, and the unfortunate short answer is that we don't quite know what this will look like long term, because as the question so thoughtfully pointed out, it will be very hard to stop a lot of the balls that are already put in motion because of the shadow docket, even if the court later comes to the conclusion that its temporary unexplained ruling didn't quite hold up when it considered the issue fully, which I think it will for many of these cases will be the case, because funding has already been lost, people will already have been fired, the heads of agencies will have already been removed and someone new will have been acting in their role instead. So it's going to be very hard to unwind the clock. And again, we'll be thinking about long-term rebuilding efforts years down the road. But part of what we can be thinking too is about what we might want Congress to do in reaction. If we have a Congress, we haven't had a Congress at this point that's particularly engaged in figuring out how to kind of retain its power and see some of it back that's been ceded to the president. But there's a lot of things that Congress can and could do in the future to really reassert its authority. It could, for example, with funding, work to make new legislation even tighter so that there are absolutely no loopholes that the president could try to manipulate in withholding funding. It could try and just create stricter legislation. It could use its oversight powers more broadly. There are things we can think about longer term, but in the short term, it will be difficult to unwind the clock, unfortunately.
So staying engaged and surviving is sort of what we can do for the next immediate days.
Yes,
Amazing.
Holding out hope, and also Supreme Court reform is something that is not entirely unrealistic. Something to also think about when we think how we can make our Supreme Court more fair and representative of our democracy.
Thank you. Thank you. We had a question about what the courts can do. So there have been 35 plus instances of the DOJ providing false or misleading information for their cases. What can the judges do to correct this or anything? Can they impose penalties against the administration for the damage that is being done in these cases? And you spoke, actually, I'll let that be a second question. I'm giving you too many multi-part questions. My apologies.
No, that's fine. That's exciting. It means we have a lot of great engaged folks on. So yes, there are things the court can do. Courts can always hold people in contempt when they refuse to follow court orders. They can fine those people, and they can also sanction attorneys. And later down the line too, the associations that bar or give licenses to attorneys, if they have experienced such punishment by the courts, or if they have just looked at the public records of a lawyer's behavior and said, this is not consistent with our ethical responsibilities and lawyers in this state, they can revoke law licenses. And that is no small threat. And that is why we've actually seen quite a few lawyers leave the service of the federal government, I would suspect at this point, because they do not want to risk their law license. And also, a lot of these people are really upstanding career civil servants who knew they were being asked to perhaps disobey the law or not give truthful answers to the courts. So the court does have the power to fine and punish these actions through those means. And also, of course, it can punish the administration when it comes to the legal proceedings by refusing to give it any benefit of the doubt, and by instead saying, I'm going to analyze everything you submit to me as the court with a fine-tooth comb and make sure I craft every order I can. So it is very, very difficult to get out of.
Amazing. And you spoke about that in your presentation as well, that they are giving the DOJ less leeway, less trust. Do you see that as a sign that our checks and balances are acting as they should, or is this a sign of like a further breakdown of the normality?
That might be a yes and no answer. In a way, it is a breakdown of normality and norms that we have held for a very long time, that the Department of Justice is losing this presumption of regularity. And it's also a very good sign that courts are holding these people accountable. But I do want to remind people, we have been here before. The Department of Justice faced a similar really decline in trust following the Watergate scandal in the 1970s. And the Department of Justice really worked for years to build back that reputation. They installed new checks in the Department of Justice. They instituted new codes of ethics and rules on when you could communicate with the executive branch. And they did successfully rebuild that trust. So while it is very disappointing to see this happen now, we actually have been in, I don't know if identical, but similar situation before. And so we can see what the path might look like going forward to really rebuild an institution that is so important and has historically had such incredible, brilliant attorneys in it.
Thank you. That's a good perspective to have. How do the court's abilities to sort of guide the administration, how is that affected by the Supreme Court ruling that seems like it held that the president could not be in contempt while performing his duties?
Yes, it's been I don't know if anyone has a good answer for this, but I think you might be talking about the immunity decision, what's known, that came out, I think just over a year or so now. And it's made it much more difficult, I think, both theoretically for the president to feel as though there are any immediate consequences for his actions, and also to, in the short term, really penalize the president himself for violations that might happen in office. Now, the fortunate thing is that hasn't really, in a lot of these cases, been a technical legal issue at this point, because when you're suing the administration for a lot of these actions, you're not actually suing the president. You're suing the agency that might have done something at the direction of the president, or the highest agency official at that agency. At one point, we were all suing Elon Musk, for example. So oftentimes you're not suing the president himself, you're suing someone else. And so that immunity decision, while very, very troubling, has not come up in a lot of these cases thus far, at least explicitly.
Interesting. Okay, we did have a question in the chat related to that and about the the appointees like Elon Musk, Stephen Miller, others that have been appointed by the president without being approved by Congress, and other sorts of favoritism like that, like the conservative press access to the Pentagon. What can be done by that, about that rather?
Yeah, so I'll take the individuals who are exhibiting such immense power. And the complicated answer, or rather technical answer to that question, is that there's a test involved for when someone has to be is exercising such federal government authority that they have to be approved by the Senate, subject to their advice and consent. And it's actually a pretty high threshold. And unfortunately, for better for worse, we do see a lot of people in the federal government, like the chief of staff, that wields immense power, regardless of the party of a president, but isn't actually approved by the Senate. And that's because there is that constitutional test with a lot of complicated, nuanced details to it. But I think the person that has gotten closest to actually meeting that test and needing to be appointed has been Elon Musk, based on the vast amount of authority that he explicitly said he was exercising, that the president said he was explicitly authorizing, and just the mass authority that he was existing across different government agencies. But as we've all seen, he has since left government service, which is kind of mooted out or rendered unnecessary to decide a lot of the cases that were brought against him on those grounds. So we haven't gotten a really clear ruling from a higher court on this issue, although we did get several lower court rulings before he did leave government, saying that he had violated the appointments clause by the nature of the power that he was wielding without having been approved by the Senate. So there is some precedent for this going forward if we were to confront a similar situation with someone acting with as much power as he was, for example, without being confirmed.
Thank you. And in terms of another test of legality that we might be having coming up, what about the executive branch's actions with ordering the National Guard to state? Where does this fall within the presented domains? And how do you interpret the legality of these actions?
Yes, that is a very complicated question that I will defer you fully to my colleagues who work on that issue day in and day out in our wonderful Liberty and National Security program. But what I can say is that just at a non-expert level on my part, there is very, very good evidence that these actions of deploying federal troops to resolve warlike crises in places where there is very much not an actual war or insurrection, whatever you want to call it, going on, violates several very well-established laws. And I think we will likely see courts act on this. We've already seen some of them act on this, and the issue already is going to make its way up to the Supreme Court, I think, based on the track that it's going on now. But there are very clear federal laws in place that restrict the president from doing precisely this thing in places like Illinois and Oregon, LA. And I think we're going to see a resolution on this at some point sooner rather than later, because there are so many cases percolating right now.
Fingers crossed. Can you direct us to a good place where we can get a primer on what Supreme Court reform might look like?
I absolutely can. Let me see if I can pull it up quickly for you, and if not, I will send it out. I believe this page here should have all of our resources on it, with resources for what that Supreme Court reform might look like, what has been tried in the past, what may be successful in the future, what our timeline might look like. So definitely encourage you to check that out. And if folks do have questions, they're also welcome to, of course, email me, and I can direct you to some of our colleagues who have spent years thinking about this very issue and have very much played the long game.
Amazing, thank you, especially for pulling up those links so quickly. How might the weakening of whistleblower protections be overcome legally?
How might the weakening of whistleblower protections be overcome legally? That's a fascinating question that I don't know as much about, but I think the one thing I do know, which I think you all have probably seen, is that we are seeing more and more whistleblowers, as we did during the first administration, It's incredibly courageous for these people to step out and to be doing what they're doing. I would imagine that protections can be strengthened by Congress, but it's something that I think we should all certainly be advocating for to the extent we can. And while I'm not an expert on it, there are many great organizations that are devoted exclusively to whistleblower protections that I would very much encourage researching, looking into. They have been working on this issue for decades and decades and have put a lot of thought into it.
Thank you. I want to do at least one more nitty-gritty question and then get into some of these really great general questions that we've gotten. But for the nitty-gritty, what are the rules, laws around the executive branch receiving donations, including if those donations are made anonymously?
Around the executive branch receiving donations, that is a very complicated set of ethics rules that I definitely know I should not be advising you on the details of, because there are also people who have spent their entire lives dedicated to those issues. But I can tell you there is a White House gifts office for a reason. There are rules and norms around what the administration is and is not supposed to accept, conflict of interest rules. And while it is sometimes difficult to enforce those rules, or especially when they are norms, not laws, they do exist. And so that is something that you can get a lot of information about through things like FOIA requests, Freedom of Information Act requests. And a lot of organizations are doing that work to uncover what donations are coming in and who is kind of paying to play in this space. And so it's something that a lot of organizations are looking into. And as more and more of that information comes in after things have been requested, we'll know more. But I think we already are seeing a lot of groups requesting that information. So the question asker is absolutely on the right thread.
Thank you. Okay, we've got two questions that are pretty related. The first one more broad, the second one a little more specific. In your professional opinion, is the Constitution strong enough to stand up to all of this? And on the more specific end, what specific tighter federal laws could prevent the irreparable harm being done with the delays while challenges move through courts?
An excellent question on both counts. The optimism in me would like to say that our Constitution can withstand this. We have been through many crises in our country's past, and while we might come out of this particular constitutional crisis, if that is what we would like to call it, there is a very reasonable debate about whether or not we are already in it. There are certainly things we can do to strengthen our Constitution as we look at amendments. I do think it is sufficient enough to withstand it, so long as the people advocate for it and really fight for it. We've seen that a lot of these abuses of executive power are really unpopular when people actually get information in an unbiased way and understand what's going on. Part of what's so difficult is just that it's really, really hard to filter through the noise and get unbiased information about what is going on. So to the extent that we can all have conversations that explain the gravity of what's happening, tell people why we think these things are important to us, and create that awareness, something that the League of Women Voters, I know historically, has done extraordinarily well in encouraging people to go out and vote and express their views. That is what will ultimately change the balance here, is making noise and doing that hard work on the ground ourselves. And the second part of your question was, oh, I do remember what laws we can do in the meantime, what Congress can do. And some of those things we discussed, I think a big one as we hit the next fiscal year, pending the resolution of a shutdown, is creating really, really tight funding laws. Another thing that we can also look forward to when we see a lot of these Supreme Court decisions come down, if they may not go our way, Supreme Court decisions get overturned in the future. We have seen a lot of decisions come down where the dissent that has been really powerful has one day become the controlling majority opinion, when we have realized as a country the error of our ways. And so we can also, in addition to trying to advocate for changes in laws, we can do the hard advocacy work of laying the groundwork to overturn those decisions in the future, when we perhaps have a different place in our country or a different Supreme Court makeup. So again, long-term changes, some short-term changes, but definitely no shortage of things we can do and work towards.
Amazing. In that vein, do you have a good elevator pitch for convincing people that they should care about what's happening? Maybe people who feel like they're not affected by the actions the administration is taking.
Absolutely. And that is just some of the things we talked about, but the harms that we're actually going to start seeing in our everyday lives. I think a lot of people don't understand how federal funding, for example, is a good thing, affects them. And that's because it might seem like a lot of the funding that we interact with in our everyday life exists on the local level or the state level, but a lot of that funding actually comes from the federal government. So things like local disaster relief or the healthcare coverage you might have, it might have a different name, but it actually comes from the federal government. Maybe you get a service from a nonprofit or a hospital, or you are in a clinical trial that is funded by the federal government. These are all things that affect every single person we know. And so when you start thinking about, well, gosh, I have a friend in a clinical trial for a cancer treatment. I know that NIH just lost this huge grant. That clinical trial is going to be stopped. What happens to that person's treatment? Then it suddenly becomes something on a really visceral, personal, local level. And so those are the kind of examples that we can give people when we explain why this matters. And we are trying to do work on our website highlighting what those are. There is incredible reporting coming out highlighting what those local harms are, but it really is just explaining to people about this could impact you or your neighbor. It is not something that is amorphous and happening to other people.
Makes total sense. Thank you. There was another question in the chat that I feel is extremely relatable to all of us. There are so many fires going on. It's hard to know where to focus our energies. Of all of the issues, actions going on with the executive branch, which few would you consider most concerning or most warranting our efforts?
Well, I will give this plug because I think it's such an excellent audience with the League of Women Voters, but that's something that I think we should all be caring about and have the capacity to change is how we approach elections for 2026. That is because we have already seen what's coming down the pipeline in terms of federal efforts to try and discourage people from voting or make it harder to vote, whether that's trying to enact executive orders that require people to provide their birth certificate or a passport when they register to vote, things we know millions of people just don't have on hand easily, or whether that's efforts to seize or otherwise gain control of voting machines in different states. We know that these things are coming. And so there's a lot that we can do up front in trying to prevent them from happening. We can encourage as many people as we can to register to vote now and create a plan for doing so. We can start volunteering with our local elections offices as poll workers. We can start changing minds and convincing people, because one of the things that's hardest to combat is distrust in elections when the federal government itself is saying you shouldn't trust election results. We can combat that in our everyday lives by having conversations with people and explaining to them why our elections are safe and secure. So that is both a very tangible thing that we can do and something that I would definitely recommend focusing on, because the core of our entire system is voting for the people and the policies that you want to see in place. And we have to make sure that we do that in 2026.
Amazing. Thank you. Let's see here. I'm trying to gauge how many questions we have time
Anastasia,
for.
I think maybe we could take maybe 2 or 3 more, and then we'll give poor Lauren a break from all these questions, and we'll wrap up. She's been a great sport.
I've been enjoying it. Thank you for such thoughtful and engaged questions. It's always a treat.
Absolutely. It's so hard to choose because they all are so good. Okay. I am going to go with, can you just briefly explain the power of an executive order?
Yes. So an executive order cannot change the law, but it can basically direct the implementation of an existing law in a certain way. And historically, they've been used for very technical or nuanced things where Congress hasn't spelled out specifics. and the president said, I want this agency or this element of the executive branch to carry out this law in this specific way. They have no effect if they violate the law. It is very well established that you can sue to challenge it in court, and a court will say, this violates the law. You can't do this. So legally, it does not have an effect if it violates the law, but that requires a successful legal challenge. And so, of course, we have to wait for that. So with a lot of things that we're seeing now, like that birthright citizenship executive order, it's creating a huge chilling effect that the president has tried to enact it, even though it is likely very unlawful and will likely be found so by the Supreme Court. It already has by multiple trial courts and appellate courts. And again, just creates this notion that things are lawless, and the president can do whatever he wants, even if that is not the case longer term.
Absolutely. And on a related note, it was asked what we could do to stop the current use of ICE in our cities. I know Eileen here on the staff shared our excellent 287G toolkit that people can use to help stop local law enforcement bodies from operating as ICE agents. Do you have anything else that we could do?
Yeah, so as the Brennan Center as an institution, I don't think we have a position on what people can or should be doing related to ICE, depending on whether or not it's legal. There are a lot of specifics, but I can say what we do know is that one of the most effective forms of getting your voice out there is public advocacy on any issue you care about. It's peacefully protesting. It is using whatever method you can of making your voice heard. And then I don't know what's in the League of Women Voters materials, but I know they always have excellent materials. So I'm sure those are wonderful as well. But as with any issue, I think being vocal about what you care about and why and what is going on in your community is the most important thing that you can do.
Amazing. And in that same vein, I would love to wrap up the Q&A with your sort of call to action. We are, as you can see, an incredibly engaged group of people. You've just given us an incredible amount of information. How do you want us to go out and use it?
Yes, I think you are the most powerful communicators, more so than any news outlet, in my opinion. And that is because people trust, we know, people that they know and people that they've had conversations with and people that they've had relationships for years. So if you can explain to people the harms of what's at stake, what it might look like if they lose their constitutional rights, why we should care that one person should not have the power of the purse and the power of the sword, because that means that we essentially have a king who does not have to follow the law and can fund and deploy the military. That is the stakes of what we're dealing with. And it's just, again, hard for that to break through in our current news environment. But we know from message testing and from research that when people understand that, they change their mind. People really believe in checks and balances and separation of powers, regardless of their political party across the board. There's a lot more agreement than we think. So if you, as our communicators on the ground, can go out and carry this message and explain to people what's at stake, I'm actually very hopeful that we will change minds and be able to change the trajectory of the abuses of power that we're seeing right now.
Thank you so much.
Well, Lauren, that was incredible. Thank you to Lauren Miller Karalunas for her presentation, and to everybody who took time out of their busy days to attend tonight and to ask such thought-provoking questions. And a reminder that we have 2 more sessions covering the legislative branch on Saturday at 10 in the morning and the judicial branch on Tuesday at 6:30 at night. And at Saturday's program, we will take time to discuss personal wellness and self-care in these times. So again, thank you for everybody who attended, for your thoughtful questions, and especially thank you to Lauren. If we were in person, I'd be asking everybody to give you a round of applause, but it looks like you're getting hearts and applauses through Zoom anyways. So
Thank you so much for having me.
And we hope to see you all on Saturday.
Yes, and I dropped the feedback questionnaire in the chat for everyone who would like to provide their insights on today's presentation. And again, from all of us at the staff and the state board at the League of Women Voters of Wisconsin, thank you so much, Lauren, for joining us. And we'll see you guys in a couple of days. Have a great evening.
Thank you all.